Good morning. So I'm sympathetic to the concerns that you have about revealing information to the bad guys, which would in some way inhibit your ability to keep us safe. But I do have to say, listening to the testimony and the exchanges, I think there's a bit of you're not getting it in terms of what was trying to be done with this bill. Military-grade X-ray vans, cell site simulators, license plate readers, sonar systems, thermal imaging cameras. These are extraordinarily powerful investigative and intelligence gathering tools. And I'm glad that you have them because they are there to keep us safe. But missing from the philosophy that you outlined for us is a due concern for the civil rights and privacy interests of New Yorkers more broadly than just the very, very narrow limits imposed by the Constitution or by courts. The philosophy that you laid out, just to quote from your testimony, I think this is from Mr. Miller's testimony. The philosophy behind, these are some of the tools we're using to keep pace with the evolving threat of terrorism. The philosophy behind them is simple. We have to develop the best intelligence available, expand our partnerships, and take protective measures to defeat whatever our adversaries might be planning next. What I'm not hearing there, and I understand that's just two sentences from the testimony that you provided, but what I'm not hearing there is limiting the intrusion into New Yorkers' privacy to the extent possible and consistent with legitimate law enforcement purposes. That balance between privacy and security is something that I'm sure is part of the department's consideration. When you say that transparency is important and the department is committed to maintaining the appropriate balance between reasonable transparency and still having the effective tools and technologies needed to protect our city, I believe that you believe that. But ultimately, do you agree that it is the public and their elected representatives who decide the appropriate balance between privacy and security?
I believe that there is a false premise that is a snowball that's been rolling down a hill. And that is the premise that there is some broad-based, overarching, undisclosed surveillance of large swaths of the public or neighborhoods or groups or cultures that goes on outside of documented, authorized investigations that are based on the probability or possibility of criminal activity or terrorism. That is simply not the case, but there is a habit now, there is a trend of calling documented, authorized investigations spying, police spying. There is a habit, there is a trend of calling sensors, whether they're private security cameras, the things that we can see right in front of us and pass under every day, calling that surveillance when there's nobody actually watching those cameras. But you can go back to them if there's an incident that has occurred or some reason. And that this is all balled up into some kind of paranoia. We operate under strict rules. The largest system concerned here is one that the NYPD proactively disclosed before it was launched, built to the code of the privacy policy that it disclosed, and operates under that policy today. The problem with this bill, and I don't want to sound like a broken record, is not the broader discussions about whether to disclose guiding policies in the use of certain techniques or broader policies on systems. It is that the bill makes no distinction, has no carve-out for redaction, has no exception for sensitive investigative techniques or equipments that would endanger lives. It is simply disclose everything, every tool, every system that you have that involves the word
I'm glad
surveillance.
to hear, as my colleague, Councilman Gorodnick said, and he is the author of this bill, I'm glad to hear for the first time that the department is willing to roll up its sleeves and get into the nitty-gritty of the language of the bill and try to address some of the legitimate concerns that you have. I would make the observation in response to your response to my question that the department has repeatedly over the years pushed the limits of what it can do in terms of intelligence gathering and surveillance, and has had to. There's a reason that there's the Handschuh Agreement. It is the result of a lawsuit that was brought many, many years ago, and over time, on numerous occasions, has had to be modified and expanded. The other thing, in terms of your concern about the misperceptions that the public has about us living in the surveillance state, my characterization of your answer is the more that we can inform the public in a responsible way about what surveillance is going on, the less paranoia, your term, will exist. But I have to get back to the question that I asked you because I need to establish a baseline. Do you agree that the balance between security and privacy, the limits of surveillance, should be ultimately decided not by the police department, with all due respect, but by the public and their elected representatives?
The balance when it comes to security versus privacy is decided on a daily basis. As Commissioner Byrne described, when you go before a court and you say, Your Honor, these are the facts as we have them, this is where the investigation may take us, and we would seek the court's permission to go forward. An independent, either federally appointed or elected judge reviews that, and as the arbiter that has operated within the system for over 200 years, comes to a judgment on behalf of the public as to whether a specific tool can be used in the micro sense. In the larger sense, again, not wanting to repeat myself, where you have a system like the domain awareness system, this system has been laid out broadly and is available for anyone to review on our website.
So, respectfully, here's the part that I think you don't get. There are tools that are available to you. There are mechanisms, there are devices that are broadly allowable. The license plate readers, for example, which nonetheless, and a court would not disrupt or block your use of them, but nonetheless, the public might feel that that kind of surveillance, that kind of record keeping, whatever it might be more than the public is willing to accept in order to achieve whatever security end.
Council member, it's been in existence since the development of that program. It has been publicly disclosed.
It's just an example of the fact that
it has been publicly disclosed.
There are tools at your disposal that are much, much, much broader than what a court would narrowly block, but which the public might think, we don't want that.
I'm sorry, and it may be the limits of my own intelligence, but I'm failing to wrap my head around a question about what the public knows or understands about something that we talk about often. In our press conferences and our interviews, we talk about the capability of license plate readers. We spent a good deal of time as a department after the Boston Marathon bombing when we were told that the bombing suspects had intended to come to New York, and we believe they were, that the license plate reader system would detect their entrance into the city.
I would never challenge your intelligence, so perhaps...
One of the reasons I get that word intelligence in my actual job title is so that it's used with my name in the same sentence.
So perhaps you're being strategically obtuse. Let's say that. There are many
Get the
tools.
dictionary.
There are many tools that are at your disposal, some of which we know almost nothing about as a matter of policy, which might be, and I assume are, used by the department in strict accordance with the law, but that nonetheless, the public and their elected representatives might think, even though this is permissible under the law, we would like its use to be narrowed even further because perhaps we're uncomfortable with this level of scrutiny, surveillance, record keeping in some governmental database. When I say that that's what you're not getting, that's what I mean.
I'd sure like to know what those systems are, because if we have those, I don't know about them.
Well, if we can pass this bill, I think we'd all get to know what they are. And yes, sir.
I want to come back to what I said earlier because I think, and I don't think you intend to do it, but respectfully, I don't think you get it. You're misusing the term privacy. Courts have ruled for 200 years under the Constitution and under the state constitution that what you choose to do in public, you have no privacy interest in, whether it's driving your horse and buggy to Washington Square, driving your Ford Mustang into New York City, going out for a lunchtime walk in front of Goldman Sachs. There is zero privacy interest in
That's
those
an
activities.
excellent point. That is the point. Thank you. That is the point. There is a strict legal definition of privacy, which a court will say to an individual, sorry, you're in the Midtown Tunnel, you're outside Goldman Sachs, you're on the street, you have no privacy. But what I am telling you as a representative of 160,000 New Yorkers is that our conception of our privacy interests and desires might be broader than that. And we would like to be able to engage the department in conversation and even direction that to say to you, with some of these technologies, in some of these circumstances, we do not want you to gather intelligence and information to the limit of your constitutional ability. We might want you to restrict it because maybe we don't want a database out there that's hackable by WikiLeaks that can, track where Rory Lantzman has been all day. That's the thing.
I think we should have that discussion. I think you should hear what we hear when we go around the city. Every tenants association meeting that we meet with in a public housing project wants to know why they can't have a camera in every lobby and a camera on every elevator. When we talk to victims of transit crime, they want to know why there isn't a camera on every part of subway platform and every part of the inside of a subway car. When we go and meet with various members of our Muslim community and clergy members, they want to know, are we watching people, and if we stop watching the wrong people because of guidelines, because they want to be safe in their houses of worship. So there's a broad diversity in New York, and there's a broad range of views on that. But what we hear all the time is that people want us to do things lawfully and respectfully, but comprehensively, so they don't get shot or killed or die in a terrorist attack.
I hear that, and I hear other things, and as the elected council member, it's my job ultimately to synthesize that and try to adopt policy for the city. And I think what this legislation aims at is to get us the information to us and to the public so we can have that intelligent conversation, strike the right balance, a word I've heard a lot this morning, and come up with a policy and policies that are best for the city. But without us having that information, and I'm not saying the exact text of this bill is the final answer, but without us having that information and understanding, we can't do that.
I think we should continue to have this discussion. I do want to point out, because there have been several references to the federal legislation on privacy impact statements, that there's a specific exception under federal law that where the disclosure of those statements could compromise ongoing law enforcement efforts, those statements are not to be made public. This bill contains no such provision.
And I endorse the spirit of that completely. Thank you.